还要找另外一个人来。还要找人。
Đó, lắm bạn.
Apa tak ada view ni?
Sabar. Dalam view ni.
Ni
Habis ke tak ada? Macam tak ada.
tak ada.
Lepas dah balik habis. Assalamualaikum. Sekarang kita berada di lobi utama. Dah. Dah, mana? Kan dia?
Gambar yang bikin.
Dah. Macam mana nak baca future dia? Apa yang tak kasi?
Orang bawa earphone lain kali.
Yang warna cerah shirt. Tak kasi saya siap.
Cakap dari tu.
Cakap apa?
Cakap je.
Duduk.
Aboh.
Duduk. Nak duduk tak?
Okey. Ni cakap.
Assalamualaikum dan salam sejahtera buat penonton The Malaysian Insight. Dan sekarang anda bersama saya Syazwan Amir di Mahkamah Persekutuan Putrajaya, di mana hari ini Mahkamah Persekutuan telah pun menolak usaha terakhir bekas Perdana Menteri Najib Razak untuk dibebaskan dari sabitan kes penyelewengan dana SRC International Sendirian Berhad. Panel hakim mencapai keputusan majoriti 4-1 untuk menolak permohonan beliau untuk menyimak semula sabitan hukuman penjara 12 tahun bagi kesalahan menyeleweng RM42 juta dana itu. Baik, ketika ini sekitar jam 12, saat ini masih belum ada lagi, kami sedang menunggu sekiranya ada sebarang PC daripada peguam dan wakil-wakil, tapi masih belum ada. Baik, hari ini Hakim Mahkamah Persekutuan Vernon Ong Lamkiat ketika menyampaikan keputusan itu berkata permohonan Najib dibuat tanpa merit. Keputusan itu mengekalkan Najib di penjara Kajang untuk menjalani baki tempoh penjara 12 tahun. Vernon berkata tidak berlaku kegagalan dalam proses keadilan ketika pendengaran prosiding rayuan akhir kes pecah amanah, menyalahgunakan kedudukan dan pengubahan wang haram dana SRC International berjumlah RM42 juta oleh panel Hakim Mahkamah Persekutuan pada 23 Ogos tahun lalu. Menurut beliau, panel Mahkamah Persekutuan tahun lalu membuat keputusan yang betul apabila menolak permohonan pemohon supaya Tengku Maimun menarik diri daripada mengetuai panel. Keputusan bertentangan itu dibaca oleh Hakim Besar Sabah dan Sarawak Abdul Rahman Sabli yang mempengerusi panel 5 hakim itu. Anggota panel lain ialah Hakim Mahkamah Persekutuan Rod Zariah Bujang dan Nordin Hassan serta Hakim Mahkamah Rayuan Abu Bakar Jaiz. Pada 23 Ogos tahun lepas, panel Mahkamah Persekutuan yang dipengerusikan Tengku Maimun menolak rayuan Najib untuk menepikan keputusan bersalah hukuman penjara 12 tahun dan denda RM210 juta. Jadi sekitar jam 12 ini kami para media masih lagi berkampung di sini untuk menunggu sekiranya menunggu sekiranya ada sidang media yang akan dilakukan sebentar lagi. Jadi sekiranya anda bersama kami, teruskan komen, share, like dan subscribe. Sorry, sorry.
TV mana tu?
Sound okey tak? Kau tinggi pula.
Oh, so many mics.
You all heard the verdict. The review has been by the applicant, Dato' Sri Najib, has been dismissed 4-1. And legally, the accused has exhausted all avenues of appeal. It is the hope of the prosecution that this will bring closure to the SRC hearing or the SRC case. This decision by the federal court is also a vindication that the charges against Dato' Sri Najib are legally mounted and not politically motivated by the prosecution. And there's always a question, how do we feel the prosecution? I must tell you, there is no joy in a successful prosecution except that the Attorney General's Chambers has been able to ensure that the rule of law has prevailed in this case. The SRC prosecution's biggest message is to politicians or other likely offenders is that this prosecution has shown that no man in this land is above the law. And I want to stress, this successful prosecution must send a chilling message to all would-be offenders that the law will catch up with you and punish the guilty. So that's all I want to say on what the prosecution wishes to say. Is there any question you wish to ask?
Yes, since there's dissenting judgment, is there room for another review?
Well, I must say there has been legally a review is from a decision of the federal court. There was a decision of the federal court, and from that decision, this review. If you want to review upon a review, then there's no stopping a review upon a review and a review upon a review, and you can send your grandchildren here to take notes. You follow what I'm saying? So legally there is a possibility, but it is very unlikely.
What about your comments on the judgment by the single judge?
No. As lawyers, we accept both the judgments. It is their view. I can't give my view because I'm not a judge. But it is their view and we accept the decision. Yeah.
Sir, tell us about the the individual role they play, from the High Court to now. Can you tell us how teams work?
Okay. Of course, you all know that the prosecution we started about with 12 prosecutors in the High Court. Then it slowly dwindled. Some of them retired. Some of them left service. So we are now left to 5. I think, as you all would have seen, we have a very good team spirit. We work with each other very closely. Although I'm based in Penang, we are always in communication, and when they come to Penang, they come and see us, we discuss cases, and similarly, I come to the AGC and we meet up very often to be abreast with the development in this case. Yes. Anything else? Okay, that is actually something outside our judicial system. I mean, appeal to UN is not provided in our law. Obviously, it's in the international law. One thing I can say for sure, that whatever the decision is not binding on Malaysia, unless Malaysian government wants to accept it, So it is a process. Yeah. Okay? All right?
Okay.
Thank you.
Thank you, sir. Thank you. Selamat Hari Raya.
Thank you.
Okay, tu dah tu boleh balik tak? Hah? Tapi dia dah krem lah. Dia tak taruh ni.
Belum kan? Sudah?
Hah?
Dah end?
Belum.
Jam lah kalau dia berbual.
Tak okey tu baik. Tapi tekan minit dia batin. Biar batin dulu.
Boleh ikut nak off ke?
Biarlah.
这个法律的方法。在跟大家分享，因为现在大家的都是大家都来到这个大厅法庭。
Are we ready?
Yes, sir.
All right. I want to make, I won't promise a short statement. If I say short, I go long, then, then you may complain. Now, I want to make a sufficient statement about what I think are the two judgments that was handed down. All right. As you can appreciate, there is a 4-1. I must say, with the greatest of respect, that we were extremely disappointed with the reasoning provided in the majority, because it sounded like the judgment of the previous federal court with a little bit addition of some flash. Nothing much that was added that would have impressed us that we were wrong. Okay? For instance, cases that we have obviously shown to be completely non-applicable was cited again, just as the previous federal court cited, like the Halaman Pekala, which has got no application whatsoever. And conveniently, they did not handle the issue of the circular, about the circular that was applicable to the lower court. It was also given CC to the High Court and the Supreme Court. Regarding the discharge of counsel, they did not deal with it. Okay? And in the end, of course, we are further disappointed with the conclusion and the result of the majority judgment. But we are very encouraged, and I must say this, you can see that in spite of losing this case, I am still in the smiling mood because of what was said in the minority, the dissenting judge, which took double the time of quick reading than the majority judgment. In fact, it was 84 minutes of reading, and the previous, the majority judgment was only 48 minutes of reading. Of course, length or quantity doesn't matter, but it is the quality that is important. Now, I thought highlight this. This is what was held in the minority judgment. That sort of excites me because it is something which I expected a judge of the caliber of Rahman Sebli, the Chief Judge of Sabah Sarawak, to come up with, going by the historical background that we know about all his judges, which are quite illuminating and upright. Okay? Now, he said out of the 4 grounds, he was only interested to make a decision on just one ground, namely the adjournment, which is the second ground out of the 4. So he says on the adjournment, and he started by saying that Rule 137 is critical because it is a rule that not only is to propagate justice, but he calculatedly used the term. It is to stop the perpetuation of injustice.
suggesting that what is going on with Datuk Seri Najib was injustice and he has to stop that perpetuation of injustice. You see, Rule 137 is applicable in such a situation. That's important. And you see, Rule 137, even if you go by the law, is applicable when fair trial has not been given to a person. And in this case, he went down the route and held that fair trial was not given. The process was completely not provided to the person. Now, this is how he says it. Huh? He says that justice is not about finding out whether someone is guilty or innocent, or not guilty. Huh? Guilty, not guilty, or innocent. Justice is not only about that. But justice incorporates a bigger concept, namely whether when you come to the decision whether a person is guilty or not, did you apply the process that will enable him to say, yes, I have been given the fairest of trial, but unfortunately I lose, or fortunately I win. So the process is very important. Now, why you need to stress this is because it applies to you and me. Next time maybe it's not you, it could be your children, it could be your father, it could be anybody. If he is charged in court, you must be confident that the court will give you a process of fair trial. Because only the process of fair trial, you can be assured that the judges are giving you the chance to prove your innocence, or for the prosecution to prove your guilt. So if you don't get this, then you can say virtually that fair trial was not given. Now I want to jump a little bit. This judge in the minority held that there was no fair trial. The adjournment should have been given. Because why should the adjournment be given? He said because the new lawyers took over the case only 3 weeks beforehand. Okay? But he said it is not relevant about Shafi and Co. that was already there 4 months before. Because Shafi and Co. was no longer the lawyers. Because they were replaced by Ziz and Isham. So you have to consider the new lawyers. So the new lawyers had only 3 weeks to read over more than 30,000 documents and judgment which are 800 pages in the High Court and another 300 plus pages in the court. So you see, it is humanly impossible. So in the context of that, you see, the judgment should have been given, and he says it is routinely done in especially serious cases. And you remember we cited the case of one person who got 70 on. You know, nobody complains about it. Yeah? Because if he needed the 70 adjournment, he should get the 70. But this is the first time we ever asked for adjournment. Never before in the history of the Constitution. So I want to impress upon you that because he thought fair trial was not given to his client, this judge did not order for a retrial in the federal court. He said because the infringement is so drastic, so big, he ordered an acquittal and discharge. That means if Rahman Sabli was the majority, Datuk Najib today is acquitted and discharged and there is no more trial on the SRC. It is that serious. And he is the most senior judge there who decided. So bear in mind, we pleaded either you acquit and discharge or you order a retrial before a newly constituted federal court judge on the appeal. Will the appeal be reheard? Because Tunku Maimun and 4 judges did not hear us. You remember we said they heard the prosecution ex parte, one-sided. They never heard from us at all. And they held that when Hisham stood up and said he cannot submit, it is not because he refused to submit. It is because he's being responsible. He has not been prepared because he just got it 3 weeks earlier. and therefore he cannot do injustice to the client by submitting when he's not prepared. Not like if you are being defended by a lawyer, you will be very, very upset if the lawyer is not prepared, and yet he carried on with your defense, because that's the best way to handle it. You know, sometimes the lawyers themselves can hang the client. Doesn't have to be the prosecution. So the lawyer must be fully prepared in order to defend you. And this is your basic right. Alright? Okay, now, then he went on about the adjournment. He said, why shouldn't the adjournment be given? Because the adjournment was requested a lot earlier. The prosecution did not object. On 2 occasions on record, he read it. The prosecution leave it to the court, no objection. Not only that, the prosecution sent the Solicitor General. This is the 3rd occasion. The Solicitor General stood up and said, we leave it to the court on the request for adjournment. Which means they were quite confident. The prosecution was quite confident that the request for adjournment was genuine because they didn't do it. There was no such thing as was it a ploy to delay. Because if it was a ploy to delay, the prosecution will make noise. The prosecution at that time never had any idea that this was a ploy or anything. They all thought this is a genuine request for adjournment. And it remains a genuine request. But only here they began saying that is a ploy for adjournment, which the judge just now gave them a rap on the knuckle, saying this was an afterthought. Alright, so the minority judgment says once the application for adjournment is genuine, you have to consider it in a reasonable fashion. You cannot simply say this is a discretion of the court, because the discretion of the court must be exercised judiciously. That means just because it is discretion, you cannot do as you like. You have to consider it judiciously, because if you don't grant adjournment, it may cause injustice to the city. So that's why you have to be judicious about every decision, including for adjournment. Now, then we went on to a sub-issue, which is this. He says, he examined this concept of can a council discharge himself? You remember Hisham discharged himself at one stage. On the 18th, he discharged. But the court said, no, we are not allowing you to discharge. This dissenting judgment says there is no such thing as not allowing, because the circular as well as the 2 cases we cited, when you engage, assuming you engage, it's a private contract. The court cannot enforce. The court cannot say you must continue engaging, because that's enforcing a specific court. If she wants to set me, that's it. The court have got no say, so it's a private contract. So the court said this was a private matter between the client and the solicitor. If the counsel says he is discharged, he is discharging himself, the court has got nothing to say about it. In a criminal case. Now, a dangerous precedent was set today by the majority. Now, the bar council representative was there, and I'm sure she's very concerned. Now, they say, in every criminal case, for a criminal lawyer to discharge himself, he must seek the permission of the court. Now, you tell me, in a last-minute appointment of lawyers by, say, people who are without lawyers, say, legal aid people, you know, people who are without money, indigent client. If suddenly they say that they met you in court and they say, can you help me, can you defend me? No lawyers will accept. Because the court will force them. You accept, you jalan it. Although I'm not prepared. That is the dangerous precedent which the court, majority judgment is set. Whereas previously, if I'm not ready, I ask for request. The court always, I've never come across one single case where the court never did, unless it is habitual that you've been asking 5, 6, there's one case 17 times asking for a judgment. So the court can stop. But in a genuine case, in order to achieve justice, the court always and the discharge of counsel is the counsel's privilege together with his client. So the court decided today, in the minority judgment, that it is wrong not to discharge not to allow the discharge of the counsel. In fact, the court went in a conclusion by saying the reason why the Chief Justice or the previous court insisted that Hisham stayed in court was to give it the appearance, it's a pretended impression that my client was with a counsel. That's why it doesn't allow the discharge. That's very dangerous because if you have a counsel that is not prepared, it is as good as not having a counsel. You remember the Chief Justice decided in one case, I did. It's called Yahya Hussain. Yahya Hussain was previously defended in Tawau by a lawyer who never knew anything about criminal law, especially dangerous crime. And what transpired was, he collected the money upfront and he pretended to defend. And then we realized later on why he wanted to do this, because the lawyer was dying of cancer. So he needed the money, took the money, but he didn't defend. And he was almost going to be sentenced to death. Then the embassy called us, and then we read the report. See, this is crazy. And IO was not cross-examined, main witnesses were not called, the wife who was present in court was not called, and so on. So we applied for additional evidence. Oh my God, now that among other things, she said, an incompetent counsel is as good as no counsel. In fact, she said, an incompetent counsel is worse than not having a counsel. Because an incompetent counsel can compromise with you. Because you are as though represented and yet not represented effectively. So if we apply that case, you force, Hisham to stay there in order to give it an appearance of being defended. And therefore, the minority judgment said that is illusory, to give it an illusion that justice was in fact being provided in the process towards justice. So those are very strong words used by the minority judgment. And finally, he held, therefore, that on the basis of no adjournment, on the basis of discharge not allowed, this is a serious transgression into Article 5, the right to a fair hearing and the right to counsel. And therefore, we see the transgression is so major that he say he orders an acquittal at discharge, not a refund. Okay? That's the short of what transpired. If you want to know further, you can ask me. But if you have any other question, you can also ask. Okay. This minority judgment has given me a lot of encouragement. We have just heard from United Nations that our application in United Nations has started the process, and there is movement to ask the Attorney General to respond. So we would send further documents, including the minority judgment, to them, so that they will examine, because now there is a judicial finding. Okay? We will also send a majority judgment, so that the United Nations will see which judgment is a lot more sound. They will see it, and then they'll come back. That's number one. Number two, on the power of pardon, it's very critical that young people has got the opportunity to read the minority judgment, which condemns the way the case was given. And I use the word strongly because the minority judgment literally condemns how the previous federal courts conducted themselves in not allowing the adjournment and in not allowing the counsel. Only on this issue. He didn't even have to go on the other three issues. He already made finding quite clearly that this is a very bad precedent for an unfair trial that was executed. So these two definitely. But there is a possibility of another action in the court. This one I don't want to disclose yet because we want to organize our thinking in the light of judgment we give on collect and so on. And we will inform you in due course what we are doing. So it is not the end of the matter. Yes. No. No. How do you pay 200 million? When the 200 million has been, all the money that was put in the account was spent on charity and political purposes, not for his pocket. It's all spent. So, quite clearly, that money you cannot recover because you paid it towards welfare, towards political funding, and so on.
So you mentioned there's another possibility in the court that is another review or another option
That one we cannot disclose yet, whether it's a review or another procedure.
but it will be a court procedure.
It can be a court procedure because the other two are not court procedure.
But review is a court procedure.
Yes. Yes. Anything else? Yes.
Earlier, the discipline mentioned that the Najib paid the price for the mistakes made by the lawyers.
Thank you. I forgot about that. In fact, the word he used, you managed to decipher from that because I thought that was a very strong point he made. The learned judge said that he paid a heavy price for the mistake of lawyers, which ought not to happen. Because if you exercise justice and process properly, a mistake of the lawyer is a mistake of the lawyer. If you want to punish a lawyer, there is contempt, there is disciplinary proceeding. The court never took contempt against the lawyer. So why should Datuk Sri Najib suffer? Especially when you have already determined, the prosecution also determined that the application for adjournment was genuine. It is not applied to delay, right? That's a good point. Yeah. So it's a very serious point. They made a finding that there is admission that the lawyers were at fault. The lawyers themselves admit that. So the lawyer's fault should not be attributable to the client.
So earlier on, during the prosecution's press conference, Sidon mentioned he hopes that the SLC case, the effect says, will end, no more litigation. How do you respond to that?
No, I think SRC case very unlikely will end that fast. Very unlikely. Yeah, because I think my client is, even if my client gets, let's assume for a moment, he gets a pardon. I think he will still want to fight the court because he's very determined that he did nothing wrong. Okay? He was misled by people in the SRC. He never moved the money. He never had the control of the money because he was a prime minister. Why should he have anything to do with the account of SRC? So, well, we think this case it has been decided on grounds which are a bit difficult for us to comprehend. And that is the reason why we thought we should take it all the way. And we are surprised that the current federal court, the federal court just finished, didn't even allow. Why not allow him to re-argue the matter? Because he was not prepared. What is the problem if you allow him to re-argue the matter? Is there a fear that he may get acquitted? Yes? No. As a result of the minority judgment, which I thought was a lot stronger than the majority judgment, there is avenue that is open. Because there are cases that say review is not only once. If there are grounds, as long as there are grounds for a fresh review, we can always do. And the other thing is, of course, we got the United Nations as well as the pardon matter that is ongoing. He just asked me. He said, I cannot tell you at this moment. Okay? Yes.
Thank you. Thank you.
No, there is no time period. There is no time period. But the first review we file in within 2 weeks. The one that you just heard. Within 2 weeks we file it after the first federal court decided. So we will try to do it expeditiously. Any other question?
Okay, thank you guys.
Thank you. Thank you.
Like he said that